Hello and welcome to the 22nd episode of Wahl on Law. My name is Jonas Wahl, and I am a pre-law student at the University of Delaware. On this podcast, we cover what's happening across the country in law and policy and how it affects your daily life. Today, we're joined by a special guest, Professor Ken Jacobsen of the Temple University Beasley School of Law, to break down the landmark House v. NCAA antitrust settlement, a roughly $2.8 billion agreement approved in 2025 that allowed colleges to directly pay student athletes for the first time. Professor, thank you so much for coming on the podcast today.
Thank you for having me. I look forward to our conversation.
Before we start, could you tell us what type of law you specialize in?
Well, my main focus at Temple is in sports law. However, unlike some of my colleagues, I did not percolate up through academia. I was a practicing lawyer, which gives me, I think, a practical perspective on courses I teach. I did a lot of work in complex civil litigation, but I also own businesses in the sports industry. I'm a founding partner of a minor league baseball team, the Wilmington Blue Rocks, that you may be familiar with. And I also did sponsorship and negotiating deals for professional athletes, Shane Victorino, Michael Vick when he was playing for the Eagles, Julius Irving. I also worked very carefully with some of their charities. So I kind of have, that's a long-winded answer to your question, but I kind of have a broad portfolio.
That's very interesting, the clients you represented as well. I also want to define one term that will come up during this episode, NIL. What exactly is NIL and what does it stand for?
NIL is name, image, and likeness. And although it has received a lot of popularity now because of the House settlement, really NIL has existed for decades, for a century. For example, NIL is nothing more than someone that is able to monetize their either name, Kenneth Jacobsen, image, my face, or some likeness, some distinct feature, maybe my voice. And we've been using NIL in this country and actually throughout the world for decades with celebrities. Every time Shaquille O'Neal, for example, does a commercial for Icy Hot or for the General Insurance Company, he is using his name, image, and likeness to promote a product. So and really every commercial where you have a celebrity who is hired because of their name, image, and likeness, they get paid for monetizing that. Their sponsors paid them to use their name, image, and likeness. The rub is that now college athletes can do that, and now that has now brought NIL kind of to the forefront of people's lexicon.
Exactly, you got right into my next question, because NIL was such a major topic, especially nowadays, because for decades, the NCAA claimed that college athletes were amateurs. Before House v. NCAA, what did that term really mean, and why was it such an important legal distinction?
It meant a lot because as amateurs, if you received any extra benefit, and that was what the term that the NCAA used and still uses, if you received any extra benefit, that was prohibited by NCAA rules and regulations. And even in absurd examples, for example, a college athlete could not accept a ride to the airport to go home from their coach because that ride was not available to all other students. So that would be an extra benefit. So the NCAA for decades clung to this amateurism model where an athlete could not receive a nickel for compensation for any of their athletic prowess or performance. If they did, they would be deemed ineligible to play. If they had played, having received some kind of compensation, the team would forfeit all of the games that that athlete played in if it was a team sport. So it had very, very serious consequences, this amateurism model that was really at the foundation of the NCAA's policy for so long.
Got it. And they could still receive scholarships for their sport, but when it comes to colleges directly paying athletes, that was a no-go.
Right. They could receive scholarships, and most of them would. We hear the term free ride, but they could receive scholarships like someone could receive an academic scholarship to go to a school. A violinist could receive a scholarship because they will contribute to the music program. So they could receive scholarships and a little bit of extra for travel costs. But really nothing on top of that, and nothing extra tied to their performance as athletes.
Got it. So, due to all those restrictions, there was a lot of disgruntledness with the NCAA and the athletes. So, eventually, a group of athletes led by swimmer Grant House filed an antitrust lawsuit called House v. NCAA. What exactly was House arguing in this lawsuit?
House was followed on the heels of other litigation and also a change in policy by the NCAA following United States Supreme Court cases. At its core, House argued that restrictions on athlete compensation were illegal. They were a violation of the antitrust laws. I don't want to get too nerdy or in the weeds too much, but the antitrust laws promote competition. They want free markets and free competition. That's why you can't have Delta Airlines and American Airlines agree to fixed prices on flights between Philadelphia and Dallas, Texas, because that's anti-competitive. You want competition. The athletes were arguing even before the House case, but in the House case, that by suppressing their ability to monetize their name, image, and likeness, that the NCAA was violating antitrust laws, that they were restraining trade, that they were restraining the athlete's ability to earn money, and that violated legal principles under the antitrust law. And they brought a lawsuit, a significant lawsuit, and it was settled. And you had mentioned $2.8 billion. That's one part of the settlement. We could break it down more, but if one wonders what the motivation was for the NCAA for settling, I think, and I think a lot of others think, that the NCAA thought it was going to lose if it went to trial. And under the antitrust laws, damages in an antitrust case are automatically trebled, meaning if you win, you get 3 times what the damages are. And the damages in this case were by the plaintiff's expert estimated to be $2 or $3 billion. So if that had gone to trial and the NCAA lost, it was facing perhaps an $8 billion liability that might have put it out of business. So it reached a settlement.
Got it. So, with that $2.8 billion settlement, which is one part of it, where did that money go? Did it go back to paying athletes, or where else could it have gone?
Yes, and that's up on appeal. So that money has gone no place yet because the House settlement is still on appeal. But the House settlement really had a couple of components. The $2.8 billion was for past NIL damages, meaning that during a period of time when the NCAA prohibited the athletes from monetizing their name, image, and likeness, those athletes lost out on nil opportunities. And that was a quantification by experts who, do this stuff, quantification of some amount of money that was lost by athletes because of the rules that were in place that were alleged to be illegal and a violation of the antitrust law. So that $2.8 billion is supposed to compensate the athletes for past damages. Most of that is allocated under the settlement to men's football and men's basketball players because they are the sports that generate the revenue. They are the sports that generate the celebrity status. And those are the athletes that probably would have received nil money were they permitted to do that, but they were forbidden from doing that under the NCAA rules. Other money is going to women's basketball, very little to other sports. But as I said, that's all being held up on appeal in the Ninth Circuit Court of Appeals right now. I can talk about the other components of the settlement, which I think are just as important and controversial if you want.
Sure, I'd love for you to get into that.
Okay. So that is past damages. Then they have a provision in the settlement, which is kind of a very unusual, strikingly unusual provision, given the NCAA's past policy, and that is that the school universities are allowed to share initially about $20 million in direct revenue with their athletes. So what do I mean by that? Schools get paid for television broadcasts of their games. Either they have their own network like the Big Ten, or they get shared revenue from the NCAA. They have ticket sales. They have merchandise sales. That money now can actually be paid directly to athletes without those athletes losing their eligibility. It is expected and planned that most of that money will go again to men's football and the men's basketball, with some, others to women's basketball, because those are the revenue generators. So they want to return the revenue to the people that generate the revenue. That is a huge development, because that's basically pay for play. That is not even disguised as any kind of, name image. That is you're sharing revenue, and if you're sharing revenue, it's pay for play. So you have past damages of $2.8 billion for past NIL compensation. You have the ability to share directly in revenue for the school. And the third component of the settlement is really pure NIL, or what should be pure NIL. It's very controversial. That is deals that are made, sponsorship deals that are made with third parties, not direct payments from the school for revenue, but sponsorship deals. If a company wants a sponsor, pay an athlete for their name, image, and likeness, and they do a social media post, or they, promote a car dealership, they're allowed to do that. But that is, that is now regulated through a clearinghouse that was formed by the settlement, that is going to look and approve and vet those deals to make sure they're for a valid business purpose, and that they are for really fair market value. And that's where the abuse is right now. I mean, all parts of the settlement are controversial, but what has happened on those NIL third-party deals is it's not really corporate sponsors who are stepping up and writing the checks to get like real endorsements, like you would see on television, like you would see with Shaquille O'Neal or any other celebrity. They're not really endorsing products or services of a third party. What has happened is you're getting a lot of boosters and others who are sending money to the schools under the name NIL, because it's no longer a dirty word. And that money is being used to either attract transfer players, or to retain players on their roster that they want to keep. Because one of the parallel things that have made this whole system so complex is now there's pretty much an open-ended transfer portal, meaning athletes can pretty much transfer at will each year. And I think after the March Madness was just concluded, it was like 50% of the athletes who played games entered a porthole to transfer to another school that might offer them more NIL money. And of course, if that NIL money is nothing more than booster money, in my view, in my lexicon, that's pay for play as well.
That was a great explanation. And to me, it's kind of ironic that while it was a member of a D1 swimming team that initially brought this lawsuit, at the end of the day, it's going to be football and basketball, men's football and basketball, benefiting the most. So for the first time, colleges were allowed to directly share revenue with student athletes. So is it fair to say that this settlement kind of blurs the line between college sports and professional sports?
Yes, and I think it does now with the direct payments. I think it does now with these disguised NIL payments that are, like I said, really not corporate sponsorship or endorsement deals, but they're relationships with entities that are affiliated with the schools. I think we're seeing a professionalism of the certainly men's football and basketball, and to a lesser extent women's basketball. And I think that's having some serious adverse consequences. Cuts in programs, what we call the Olympic sports, I mean, Grant House, he was a swimmer, as you had mentioned, but, Arkansas had, said they were cutting their tennis program, men's and women's, because they couldn't afford it because they were funding football. They just reversed that. I read this morning because I like to keep up on this stuff. So, and then just circling back, to kind of the amateurism issue. The reason the NCAA really had to come to the table was they got beaten up very badly before the courts and before the United States Supreme Court, because on the one hand, they were promoting this amateurism model. On the other hand, they're minting money. March Madness alone, just that tournament, generates $1 billion for the NCAA. You have college coaches who are being paid $13-14 million a year to coach. So the NCAA is a commercial enterprise. And it for years it had beaten the drum of amateurism. And that may have been accurate, 20 years ago, 30 years ago. But in this era of huge media rights deals and broadcast deals that the NCAA and the schools have negotiated, as I said, some leagues, some conferences like the Big Ten, they have their own television network to broadcast their games. It just was not credible that this was an amateur model anymore. So I think certainly in certain sports, football and basketball, you're moving more towards professionalism, but what the future holds, no one knows. We don't have a crystal ball, but I see, those 100 or so schools that are the real sports powerhouses with big budgets and big money. They may break out and form their own league. They may form their own, association. They may be a subdivision of the NCAA, because not all schools are like Alabama or Georgia or Indiana this year. You have your universities of Delaware, you have your Temple universities. We are not, swimming in that pool. We're not playing in those kind of leagues. So I think what I see is some kind of separation and isolation of these other programs, top 100 programs, let's say, give or take, that will have kind of their own set of rules and their own, it could be the possible unionization of athletes. That's another, thing that's been discussed a lot in this discussion about college athletics and where we're going.
It's a great explanation. So, for my final question here, if you had to give one piece of advice to current college athletes navigating this very complex landscape of NIL and everything else going on, what would you give them?
Get good counseling. Hire a lawyer, hire an advisor, get guidance on this. Not only for looking at your deal, but also for what you do if you land one of these deals. And not all of these deals are, $5 million quarterback deals, which they exist. A lot of these are small social media posts. I mean, a lot of these NIL deals, it's like, I'll give you, a pizza shop. I'll give you 10 free pizzas if you do a couple of posts. I mean, really, they're not that big. But there are traps for the unwary in terms of contract language. I've seen contracts where an athlete, for example, is giving up their rights in perpetuity to whoever it is that are arranging these deals for them. What does that mean if 5 years from now that athlete is a pro and could be making 30, 40, $50 million, and they have to kick back some of it back because someone else holds their NIL rights. So and also tax consequences and financial planning. It's very easy, I guess, for a 22-year-old that suddenly has $4 or $5 million to blow that money, to not realize that money is taxable. So I think the best advice I could give to people, if you're doing a small deal for a pizza company, yeah, you're not going to lawyer up, but don't sign things unless you get someone to look at it. We do a free clinic at Temple University at Temple Law School for any Temple athlete, or actually any high school student, because they can earn NIL money in the city of Philadelphia, can come to us and we'll do a free vetting of contracts. We'll do NIL education. It's a program that was a partnership that we formed with the city of Philadelphia. So it was a way of recognizing that there's a lot of potential for abuse because the waters are very muddy. This is not a clear-cut area, and it's changing regularly.
That's so great. Protection is obviously a really good message to send to college athletes. They're not alone. They can always go to a lawyer to really make sure they're not being abused, like you said. So that concludes the questions I have for you today. Thank you, Professor Jacobsen, for joining me today and breaking down the House v. NCAA antitrust settlement and the landscape of college athletics. It was a great conversation, and I really appreciate your insights.
Well, thank you for having me on. I enjoyed the conversation.
Of course. If you liked this episode, make sure to follow or subscribe to Wahl on Law so you don't miss any future episodes. You can also sign up for our email list at wahlonlaw.com to get notified whenever a new episode drops. Thank you again for listening, and I'll see you next time on Wahl on Law.